Everybody, thanks for being here. We're going to open the hearing on 2438, 2422, and 2014. Yeah, you're not going to. No. Not yet. Right.
All righty. Okay, I'll let you go ahead and explain what your intent is here,
Okay.
Mr. Chairman.
Well, House Bill 20, well, I guess, Mike, do you want to explain these? We'll have the revisers explain these two bills. Thank you.
House Bill 2438 deals with emergency medical services, and what the bill does is it eliminates the designation of instructor coordinator, since that is kind of an obsolete designation, and that you can be an instructor without being an instructor coordinator. So that's, and it passed the House, and it's in the Senate Fed and State Affairs Committee. The other bill deals with the, it's House Bill 2422 dealing with the state fire marshal and with the chief inspector for boiler inspection, and it strikes the qualifications that are in the statute. The explanation of the fire marshal was that they're having a hard time filling the position, and that they need to eliminate some of the stringent requirements that are in the law. At this point, the bill's been around, I think, more than 1 year. Again, that bill is also in the Senate Federal and State Affairs Committee. I think could combine these two into a bill, and we'll deal with it as dealing with certain state employees or whatever. I haven't figured out exactly the combination, but it's, I think they're compatible.
That sounds, they're both pretty benign bills, just kind of fixes. So, committee, are you good with that? I think we're good with that.
Okay, very good.
Okay.
Just for clarification, are we putting 22 into 38?
No, we're putting them both into 2014.
Okay, those are both.
Yeah, both into 2014.
And 2014 is a bill designating dealing with highways, and the contents of that will be stricken. That's, I don't believe, would be compatible to have all three.
Correct. Okay. Is everybody okay with that?
Yes.
Okay.
Absolutely.
Very good.
Okay.
Well, our next bill is Senate substitute for House Bill 2170, the donor intent bill that we've been talking about for a couple of days here. And from what I understand, the parties have reached an agreement. From what I understand, Mr. Chairman, committee members, the parties have reached an agreement on that. And we have some handouts here to, because of the time issue, they're not drawn up yet, but these are the agreements, and I think the conferees are here that will also indicate that they're in agreement with these changes in that bill.
I would like just maybe have them run over some of this for clarification so we understand, so that when we carry it on the floor, we can explain it to people. But I would appreciate that. But yeah.
I get that.
Yeah.
Mr. Chairman, members of the committee, this 2170, it deals with philanthropic gifts and so on, and relates to judicial enforcement of donor-imposed restrictions on the gifts of endowment funds. I would probably classify the amendments more or less as technical amendments. I don't think that they're, maybe they are beyond technical, but they're agreed to by the different parties and so on. But if you want, I can go through the bill and where these amendments are going to be, or we can do however you want. A couple of things, they've removed the definition of institutional solicitation, which is on page 2. They've required the charitable organization be organized in Kansas. They have limited the endowment fund to funds donated by a particular individual donor. We've added a reference to the Uniform Prudent Management of Institutional Funds Act as a possible means by which donor-imposed restrictions could be changed to the extent permitted by law. Provide that the form for a lawsuit has to be a place in the state of Kansas. Inserted a 40-year outside statute of limitations. Provides that this section does not, Section 3, C1H, does not override charitable organization requirements to maintain their tax-exempt status. Section 4, we added a cross-reference to this uniform law, which contains a procedure for seeking court approval of a modification of a donor restriction, and expanded language in Section 5. Specifically, we added provisions that nothing in the statute prevents the Attorney General from acting to enforce endowment restrictions, a court from applying the common law doctrine of Cypress, or a charity from exercising powers granted to it by an endowment agreement. So that's the bill itself provides that you cannot seek damages under this particular act, and anyway, that's
Okay. Couple quick questions. On the 40-year statute of limitations, was that, just wondered where that 40-year number came from. I don't know if Mark can talk to that, or?
Hello, Mark Dugan with the Philanthropy Roundtable. I think the 40-year number was, let's call it a middle ground for what the original opponents had proposed going forward, or a 20, or even a 20-year statute of limitations. We would have preferred no statute of limitations, obviously, but ultimately, I think just a theory on it. If the legal representative in there is listed as the donor, the spouse, executor of the state, or someone listed in the in the agreement, and so assuming that person is living, and that person would have to be living at the time. So if a person gave someone the ability to enforce that agreement, and that person was 30 or 40 years old, they would be able to do that for roughly until they're 70 or 80 years old. So there is a logic there that made sense. And obviously we would probably prefer that to be longer, but I think in the spirit of compromise, that's where we ended up, Senator. So.
And then one quick question on number 7, just if you could explain that about the section does not override the charitable organization's requirement to maintain their tax-exempt status.
Yeah, the bill contemplates some remedies that the court can utilize. It doesn't list all of them. I think the main thing that we wanted to ensure that folks understood is the purpose of this was never for the donor to have their money back. The purpose was for the money to be as part of the original agreement. I think the folks, the opponents that we were working with had indicated, well, we would like to make sure that a court, in their effort to do a remedy, would not do something that would jeopardize their tax status, whereas a state court would rule something that would then put them out of compliance with the IRS and their tax status. And so we thought that was a reasonable thing and thought that made some sense to include.
Thank you. So help me understand then, with the statute of limitations for 40 years, what are they coming back to say that you have to spend X donated dollars on this specific item that was in our contractual agreement, or what exactly is that? Since he said that no, they cannot seek seek damages.
Yeah, so the goal of this, and I think it's helpful to take a half step back, which endowment agreements really aren't contracts. So they are endowment agreements, and so what this bill essentially does is provide standing to the donor who made the contribution to ensure that those agreements are enforced. And right now, there's really no venue to do that. And so really what the goal of the bill is to allow a donor who believes that their endowment agreement that they've signed, and this isn't, I think it's important to remember, this isn't something they think 5 years later or 10 years later, or an executor thinks that, hey, the donor intent was different. The only thing that they can address is what was actually in the document that they agreed to. And there are going to be certain examples where a foundation or other things need to amend their agreements. So the example I use, if somebody left a endowment to the Buggy Whip Research Institute, right? There's not a lot of purpose for that going forward. And so we do think there is going to be some necessary occasionally, and I think that happens quite a bit. And I think that's kind of probably where the opponents wanted to ensure that the statute of limitations is there to give flexibility a longer term. But we think it's a good balance of just enforcing the agreement with the language as drafted. And I hope I answered your question. If I didn't, I'm happy to go try again.
Essentially, so since they can't repay the money, they may restore the intent in some different way that's agreeable with the representative of the donor at a later date, if the donor is no longer living or something.
Yeah, the only thing we want to do is ensure that the original intent is done. So I think that's the remedy that we would most seek. I think most donors in this situation would seek is, hey, just ensure that the foundation would be enforcing the agreement as originally envisioned. And if that can't be the case, obviously there would be other remedies potentially there.
You still have a question? You're good? Okay. Are you good with the rec, or? I think we're good. All right.
Thank you.
Let's, let's tentatively see. We've got 7 bills to go over this afternoon. We gavel back in at 2. It might be pushing it. And we've got a very quick meeting. Why don't we do it like we just did with the last one? With the elections, we just have to literally sign a couple pieces of paper. And so we'll just put it at the recess of the second chamber this afternoon. So once if you recess first, whenever we get done, we recess, we'll just meet you down here. And we can, because the other literally will take 2 or 3 minutes, and then we can finish up our work on that. That'll probably be the best thing, so.
So, Mr. Chairman, so when we meet again, what will we be doing exactly?
Well, we're not 100% sure if we'll be doing anything. Tentatively, it'll be continued talks on 322, which is that tribal compact. But we'll see. There's some snags we're running into on that complicate matters a little bit from what we understand. So if that's amenable to you guys, just, yeah.
Committee, members, is that okay with you? Okay, one thing I might bring to your attention, and we're working on this kind of at ourselves, but we have House Bill 2378. It was conveying the money, the land from ks to the veterans.
Right.
And we found that today.
I heard about this.
Okay.
Yes.
Okay. So I want to put that on your radar screen. It passed the House 122-1
Okay.
back on February the 23rd. And time, I think, is of the essence on that. If we don't do something to convey that land, that's going to put the time frame of the bill starting to build the veterans home off by a year. Now, I'm looking for a shell at this point in time.
Okay.
If you have any ideas about how to do that, certainly bring it to our attention.
Let me see if there's a shell somewhere we can find, or if you can find a shell, and we'll go from there.
Okay,
Yeah, that sounds
very
good.
good. I just
Okay.
wanted to put that on your radar.
Okay, that sounds good. So that, what was that,
2378.
2378? We'll put a question mark on that and find a shell. Yep, that sounds good. So when we recess this afternoon, after both of us recess, we'll come back down, resume. I might have to just sign a couple papers with the Elections Committee on your side real quick and be done, so. Okay.
Thank you.
Hey, thank you.